Have a seat, please. Good morning. Welcome to the District Court of Appeal for today's oral arguments. Today we're actually running 3 panels through here, 3 sets of cases. It's going to be a fairly busy day. This is the first, obviously, at 9 o'clock. We're not going to be taking our customary little break, our social hour or social 10 minutes. We may take a comfort break as we get into the docket, but just to let you all know, if you're second or third on the docket, you should be ready to go as the cases come up. We will take the cases in order. First case is State of Florida versus Barnes.
May it please the Court, Counsel. My name is Christine Gardner. I represent the State of Florida in this case. Under the facts and circumstances of this case, the trial court made 2 errors when it granted I'd like to reserve 7 minutes for rebuttal. Mr. Wheeler jinxed that this morning for me by reminding me to ask. The trial court erred as a matter of law when it determined counsel performed efficiently because trial counsel made a tactical decision in this case after careful consideration. The trial court failed to accord the appropriate deference to experienced counsel's decision. And the trial court essentially found in its order that counsel was per se ineffective because the defendant would have been entitled to receive the instruction had he requested it at jury trial. Finally, the trial court erred when it failed to conduct the prejudice analysis required under Strickland's second prong.
You don't think the fact that he was actually convicted of manslaughter is de facto prejudice?
No, Your Honor. Respectfully, he was tried on a charge of second-degree murder, and he was jury pardoned down to manslaughter. The State proved all the elements of the second-degree murder. So through the effectiveness of counsel, he managed to only come out with a manslaughter conviction.
Why can't we do it then? Why can't this Court does, believe me, we do the second prong and the first prong analysis all the time on summary 3850s. Why can't we do it on this case where we have a record?
Oh, I believe this Court could undertake that if it chose to. Normally that is done by the trial court. However, this Court does quite often engage in that exercise. This Court has the option, obviously, to make that decision or to remand it back down to the trial court for the trial court to make that determination based on the record.
I guess what I'm trying to get to is the primary thrust of the argument and see how it flies. Isn't the primary thrust of the argument that at the end of the day, to coin a phrase, the trial court simply said, hey, it looks like on the facts, at least on the defendant's testimony, he was entitled to this instruction, and therefore, the trial court sort of treated it as if it were a direct appeal.
Correct. That is the exact thrust of the State's argument. This is not a direct appeal, and the Florida Supreme Court and all the rest of the courts have repeatedly stated that once you get from direct appeal and you're in post-conviction relief, the standard drastically changes.
So, counsel, is it the State's position that the trial court applied the wrong principle in granting the defendant a new trial?
It did. And even under this Court's decision in Mathis, which Your Honors, Judge Kahn and Judge Lewis participated in, Mathis was a completely separate set of facts. And in that case, there was no testimony from counsel that he had made a reasoned decision not to request the instruction. And in fact, in Mathis, he actually argued justifiable use of non-deadly force. In this case, the justifiable use of non-deadly force was not argued, and in fact,
Tell us what this difference is, because the defense in their brief, and of course at the hearing below, talks about the difference in self-defense and justifiable homicide, that sort of thing. What's the difference in these 2 instructions? Well, it seems like you'd have to be some kind of a genius to understand these instructions.
Quite frankly, this is where lawyers, carry the game instead of the public.
What's the difference? In these 2 instructions?
Well, the justifiable use of non-deadly force instruction essentially comes down to whether or not a deadly or dangerous weapon or a weapon likely to cause great bodily harm was used. In this case, it was a wielded knife. The defendant testified himself that he spun around with his arm fully outstretched and the knife in some position. He demonstrated that for the jury during his cross-examination. Defense counsel chose to have that instruction read, but he did also make an argument as to, I guess you'd call it the middle prong of the excusable homicide portion of the instructions, and that was that the killing occurred by accident or misfortune. Certainly, the defendant didn't know when he held out the knife that either the victim would impale himself on it, or certainly did not know that it would result in his death because of the iliac.
It was given.
It was given as part of the, the standard. So that was given, and it was argued, but it was argued in a way that kind of fit within the testimony of the case, and that was the misfortune portion of it was the severing of the iliac artery, that the death was, not a foreseeable outcome.
Well, then, counsel, does trial counsel's discussion of excusable homicide in his opening statement contradict his testimony that he was not relying on that theory?
Well, I think that nobody really pointed out that they had indeed talked about that. And in opening statement, as this Court is well aware, quite frankly, the facts of the case often become something quite different as the case progresses. I don't think he recalled making that argument, and the thrust of the post-conviction motion had nothing to do with the excusable homicide instruction. Certainly those questions were asked at the evidentiary hearing in this case. But the thrust of the defendant's argument, and in fact his written argument, was that the trial counsel had performed ineffectively, basically citing Mathis, because he had not requested the justifiable use of non-deadly force instruction. So anything to the addition of that is simply, surplusage and discussion.
If I understood you correctly, the excusable homicide instruction that was given would have essentially allowed the jury to find him not guilty for the same reason they would have found him not guilty for with the defense instruction that he wanted and didn't get, if I said that all correctly.
I believe that is correct, Your Honor. What happens is the three instructions, there's the preamble to the homicide instructions that goes out, and that, includes your normal sort of language, which I think covers generally. I didn't bring the full instruction with me, his full instruction with me, but that was read to the jury, and then he crafted a special self-defense instruction that was read to the jury. And then that special instruction included the justifiable use of deadly force. The deadly force instruction uses that force likely to cause death or great bodily harm kind of language. And really, when you wield a knife, a jury is not going to simply think of non-deadly force once they've heard the instruction on both deadly and non-deadly force, because in fact you have a dead victim in this case. You have a victim that was stabbed with a knife, probably 6 to 7 inch long knife. We know it wasn't a meat cleaver. There's no photograph of the knife in the record and post-conviction. We know it wasn't the meat cleaver, but it was certainly the butcher knife or one of the other large knives out of a knife block set. And there was a knife block set seized at the time the investigation was begun. The other problem in this case is that no deference was given to the fact that this is a strategic decision. Trial counsel actually wrote his instructions in this case, testified that he considered and rejected the possibility of having the non-deadly force instruction. This trial counsel has been practicing law for 27 years, completed more than 80 homicide trials, and in fact has never met anyone who's done more homicides than him, and tried 9 homicide cases in the year this case was tried.
We understand counsel and experienced defense counsel in this case. Getting back to our Mathis decision,
Yes.
We noted that the counsel's actions were patently unreasonable in failing to request the instruction in question. Why is counsel's actions in this case not patently unreasonable?
To go through the Mathis facts, in Mathis you had an inmate in the county jail who testified that he struck another inmate with closed fists. There was also a mop ringer, the standard type, institutional type, that was alleged to be involved in the incident. The state's theory was that he had been struck with the mop ringer as well as closed fists. The defendant testified the only time the mop ringer was in play was they had a little struggle over it and then it was down. In that case, counsel requested only the justifiable use of deadly force instruction. It was denied. He did not then request the non-deadly force instruction, because the reason it was denied was because because based on defendant's testimony, it wasn't appropriate. The next thing that happened was he comes up on post-conviction, and, well, I guess actually a closing argument, defense counsel argued only that it had been justifiable use of non-deadly force. That was the only defense to this charge. He had admitted to the battery. He admitted to pummeling him with his fists. In this case, that's not what happened. In this case, there were multiple defenses, including state's failure to meet its burden of proof on the second-degree murder, excusable homicide, justifiable use of non-deadly force, all of which were defenses to the charge and all of which were argued to the jury, and all of which could have resulted in an acquittal, and indeed something resulted in the acquittal on the second-degree murder charge and the conviction for manslaughter. So factually, Mathis is very, very, very different, and it's also very different legally because trial counsel there never testified to making a reasoned decision. And in fact, trial counsel argued that justifiable use of non-deadly force was the only defense to the charge. So here, that's just not what happened. It's just completely factually and legally different. There was no way that trial counsel there, even if he had testified as Mr. Smith did in this trial, in the evidentiary hearing, there's no way that it could have been a reasonable decision under the way this Court applied the law and under the facts. And with that, I'd reserve the rest of my time for rebuttal.
Selig.
May it please the Court. My name is Stephen Seliger. I'm here on behalf of Mr. Barnes, on behalf of the Office of the Public Defender of the Second Judicial Circuit. This is, I think, a case that's an extension of Mathis. I don't think there's any dispute about that.
Counsel, would you agree with the state that the trial court applied the wrong principle in granting the defendant a new trial in this case?
No, he did not. I mean, the two prongs of an ineffective claim are, was the lawyer's decision constitutionally reasonable? And if it was not, whether the defendant suffered prejudice as a result of that constitutionally unreasonable decision. That's what the trial court did. I'm not exactly clear, but I think the state focuses on the first prong. Was the decision by Walter Smith not to ask for that instruction a constitutionally unreasonable decision?
The trial court reached the second prong.
Yes, because that's what Mathis says. By citing Mathis 2, the trial court reached the second prong. By not requesting that instruction, where that instruction offers a complete defense to the charge, I think Mathis says that is prejudicial to the defendant.
Is it not an important fact, maybe not, that your client, by his own testimony, purposefully armed himself with a deadly weapon at some point in the encounter?
I'm not sure why that would be important, because, and that's the answer to my question, is I don't think it's a relevant inquiry. But let's understand self-defense. Self-defense is kind of the common usage for what lawyers call justifiable use of force, okay? And so there's two kinds of justifiable use of force in defending against a criminal charge, deadly force or non-deadly force. Excusable homicide is an entirely different animal, which has nothing to do with this case.
Well, why doesn't it have anything to do with this case? Because I thought the defendant's version of events was I held the knife out and he impaled himself on it, that it was an accident. So why wouldn't that instruction that was given cover the defendant's theory of the case or the defendant's testimony?
Right, because Mr. Barnes had a knife. I mean, the excusable homicide, I think by its definition, excludes having a deadly weapon. And he has a knife. And you're talking about an accident. And as Judge Conner, maybe now this fact becomes relevant, is because he does get a knife. So he's down, he comes out of Mr. Ragland's apartment with a knife in his hand, with an intent that he's thinking, well, I don't know what's going to happen, but just in case, I need this weapon. So excusable homicide does not cover, by definition, the fact of someone taking a knife with them. And that's the cause of death in this, and that results in the cause of death. So having the excusable homicide, which is given in every homicide case, Judge Weatherall.
That's getting really back to why I'm not understanding why Mathis has a whole lot to do with this case and why you argued it's an extension. Your client purposefully armed himself. I'm not speaking to his intent at the time of the killing.
Right.
But he admits he purposefully armed himself. Mathis never made such an admission. In fact, there was a very stark dispute about whether Mathis ever armed himself at all with anything other than his fist. And second, Mathis was apparently not entitled to the self-defense instruction.
Well, he was. That's why the case got reversed on post-conviction, because he was entitled to the
I thought he
self-defense.
was entitled to the non-deadly force instruction, the instruction you want in this case.
No, I think this court says, I'm reading the opinion, he should have been entitled to jury instructions on the justifiable use of both deadly and non-deadly force had both been
But
instructed.
he did not get the deadly force
No,
instruction
that's
at
right.
trial.
No, I understand that
So
there are...
his counsel apparently had believed he wasn't entitled to that instruction and didn't even argue for the other instruction.
I'm not arguing there are factual
I
distinctions.
just don't even see the line, to tell you the truth.
Okay, well, I think the line is there is because you have a case where the lawyers believe that at least one prong of that justifiable use of force should be given to the jury, but they're not the other. And what Mathis, I think, says is when you're entitled to an instruction that gives the defendant an out to the criminal charge, then that's ineffective.
All right, help me understand, maybe I'm a little slow this morning, but help me understand the distinction between the two instructions, the one that was given versus the one that was not given, and why the defendant's testimony, theory of the case, entitled him to the one that was not given.
I think if you read the justifiable use of deadly force and non-deadly force, they're exactly the same, Judge Weatherall, with the exception that the instruction puts non-deadly instead of deadly. I think they're exactly the same.
Mathis was charged with aggravated battery.
Yes, sir.
And what was the defendant charged with in this case?
Second-degree murder. But, and if I need to answer your question more, Judge Weatherall, tell me, but if I...
Go ahead and do that one.
Because I'll forget his question if I do that. But here's the point, here's an point I want to make. This is a case, although there's a person who's dead, if you remember on this record, the state requests an ag battery instruction, which under normal circumstances, you don't get in a death case. In death case, you get only death choices for the jury. But in this case, the state asked for an ag battery instruction, and the judge gave a battery instruction. And you'll recall, the jury question in this case is, Judge, tell us the distinction between manslaughter and battery. That's what the jury came back with their question. So they're at least thinking about a non-death result in this case. All right, so I think, although they're charged with different crimes, ultimately the jury had a choice of a comparable crime that Mr. Mathis did.
All right, go back to mine. You said the only difference between the two instructions is the insertion of the word non-deadly.
Right.
How does that, given that it was a butcher-type knife, apparently, how does that fit into the defendant's testimony and theory of the case that he spun around and the guy impaled himself?
Okay, well, because he comes down with a knife, not thinking that he's going to use the knife. He doesn't take the knife out until he feels threatened by Mr. Spites coming at him. He doesn't, according to his testimony, he doesn't make an aggressive move in response to Mr. Spites' behavior. I think that, I mean, it's a subtle difference, Judge Weatherall, but I think it's important because...
But I guess my point, my concern is, it's taken this long for me to understand it, you to explain it to me. I mean, how would the jury, I mean, they got an instruction on self-defense in the broadest sense. I mean,
Right.
How are we to expect the jury to parse out this distinction so much to think that it really would have made a difference?
Well, I mean, I hope that's a philosophical question because that's why we have jury instructions, and the rule is juries are supposed to understand how we write instructions. But here's the point about that. I'm not sure this answers your question, but here's a case where in opening statement, the experienced lawyer said, here's a theory of defense we have. I mean, it could be that Mr. Spites aggressively came at him and Mr. Barnes stabbed him in response to that. But another theory is that Mr. Spites, as you recall, is 5 times the drunken limit. I mean, he's totally out of it. He's angry when he comes over to the house. The medical examiner testifies that impairs judgment. He may have problems walking, being that drunk. And so there's some physical confrontation before the knife comes out. And so the lawyer sets all this out in opening statement. He presents testimony consistent with the idea that it's not necessarily Mr. Barnes stabbing him in response to something Mr. Spites does. Like Mr. Spites has a weapon, and so he's responding to that.
Let me try it this way. Taking the philosophical, rhetorical jury question out of it, we're here looking at the constitutional incompetence or not of this particular lawyer. I mean, shouldn't we give him some deference, being a 20-some-odd-year defense attorney, given this very subtle issue? He obviously understood it, and he made a conscious decision to not present or not to ask for the non-deadly. I mean, shouldn't we give that some deference here?
Absolutely. Walter Smith is a great lawyer. I don't have any complaint about that.
Getting back to that point, though,
Sure.
counsel, and getting back to our Mathis decision, which
Right.
is key here. In Mathis, there was no instruction on the justifiable use of non-deadly force, was a question on the record, and appellate counsel did not object to the jury instruction. Here, trial counsel did request an instruction on self-defense. Why should we find that his tactical decision was ineffective assistance of counsel?
Okay. The predicate for both of your questions is once you label a decision tactical, we lose. I mean, lawyers make decisions in trials every time we stand up or don't stand up.
If the lawyer testifies it was tactical, you don't lose.
No, I'm not saying that. What I'm saying is once the court labels it a tactical decision, we lose. Okay? There are decisions, and then the court reviews that decision. Once you give it that label, Judge Lewis, that it's a tactical decision, you're going to reverse this case. The question is whether it was a tactical decision, and that's what the trial judge made the decision, that it was not, even given the fact of Mr. Smith's experience trying homicide cases, because this is not a case where Mr. Smith said, I know the facts, I've tried these cases all the time, it doesn't make sense to me that a jury is going to believe a theory of defense that says, this is what my client did. He held out a knife, and somehow Mr. Spites fell on it. That's preposterous. So I'm not going to go there. But that's not what happened.
The facts of this case are distinguishable from the facts of the Mathis.
I don't dispute that at all, Judge Lewis. Not at all. But I think the consistent theme of the cases is that the lawyers make a conscious choice to present the defense in opening, in testimony, and in closing.
Mr. Zeller, I have to say this, having read a lot of death penalty cases, but never having sat as a judge on one. You take these identical facts, except he gets the death penalty, and counsel below is successful in getting both instructions. On appeal to the Supreme Court, in the second appeal, the 3850, are you not going to have an argument that counsel was ineffective because he watered down the self-defense instruction by requesting the non-deadly force instruction?
No. I mean,
you don't think any appellate lawyer in your office would argue that?
No, but why would you? Because why would you take away any opportunity? Because
it's completely inconsistent with 99% of the defense's case in this case. That's the reason.
Well, I don't agree with that, Judge Kahn, that it's completely inconsistent with 99%. Otherwise, the experienced lawyer who's tried all these homicide cases wouldn't have presented the defense. I think that's the theme in this case, is that you have an experienced lawyer saying, I know the facts of this case. He knows them well enough that he tells the jury in opening, here's a possible way for you to resolve the case in my client's favor. And then he presents testimony.
You're sort of taking the other side of the coin and saying because that was apparently one of counsel's theories that he was then bound to request.
I think so. I think that's what Mathis.
The judge looked at it, though?
Yes, I think that's exactly the way the judge looked at it. The judge looked at it and said, because you have a lawyer who knows what he's doing, this is not a conscious indecision where you don't know what you're doing. Walter Smith knew the law, knew the opportunity to do this, went through all the motions of doing it, and then doesn't ask the judge to instruct the jury on a theory of defense that's presented to the jury.
But he did testify that it was a tactical decision not to request this instruction.
Yes, sir. He said he
is an experienced counsel.
Yes.
Now, given that as given, regarding the principle of law, absent extraordinary circumstances, strategic or tactical decisions by trial counsel are not grounds for ineffective assistance of counsel claims. What are the extraordinary circumstances in this case?
Well, and then I'll go back to my answer, Judge Lewis. When you call it a strategic decision,
Well, counsel
that's
called
the,
it. This experienced counsel said it was a tactical decision,
But
not to request this instruction.
but Judge Kahn said, just because a lawyer testifies it's a strategic decision doesn't make it a strategic decision. That's a court call, not a lawyer call. The lawyer says, I make a decision. Here's why I made the decision.
Did he
Even
carry?
if counsel testifies that it was a strategic decision, then that does not necessarily make it. But given that case, this testimony, are there any extraordinary circumstances in this case as to why it would not apply?
Yes, because here's an experienced trial lawyer who presented and argued this theory of defense to the jury that would have allowed his client to walk away from this crime. Okay, to me, this doesn't go to a lesser offense or something else. This is a not guilty verdict for Mr. Barnes, that the lawyer took the opportunity away from a jury on a theory of defense that he argued and presented evidence and then did not give the jury the opportunity to come back with a not guilty verdict.
Argued and presented evidence. The argument that you're referencing, that was opening statement, wasn't it? I thought, as I understood his testimony, as the evidence came out and came in, the theory of his case and argument changed somewhat. Is that incorrect?
I don't think that's correct, Judge Willard. I think there is a consistent theme from opening evidence presentation to closing. Thank you.
Excuse me, counsel, I have one final question here. In reference to trial counsel's testimony,
Sure.
he did say he rejected the accidental impediment theory advanced by his client because he felt it was unsupported by the facts and, in his experience, it was unsuccessful in jury trials. Given that, how does this decision, which appears to be trial strategy, fail to adhere to professional standards?
Because that was not an accurate representation of what happened at trial. I mean, Walter Smith did not even remember he made the opening statement where he presented the theory to the jury. What he thought was that, in retrospect, I'm thinking that this is not going to make much sense to a jury, so I'm not going to ask for it. But that's not how the case was presented, Judge Lewis. You know, it's one thing to say, you know, I didn't really think about it, or I thought about it, and then I decided not to present evidence or not to argue it in closing. But that's not what happened in this case. He did all that. He did the 95% of the heavy work. All he had to do was now ask for the instruction. I'm not sure that answers your question, but that's my answer. Thank you.
Thank you. Ms. Gardy.
Just briefly, Your Honors, the opening statement was not quite so clear that he was arguing, you know, justifiable use of non-deadly force. He never said, my client justifiably used non-deadly force. And in fact, in the opening statement, the closest that you get to non-deadly force kind of argument is, and he came back downstairs. He said, you know, Mike, when we came back downstairs, he said, when he came, stay away from me, I don't want any more trouble. At that point, I think the evidence will show is when Michael Spites is holding that piece of lumber, and when he came at him, he held that knife out just to keep him off him, and in doing so, either intentionally or unintentionally caused the wound. Well, he couldn't tell you at that point how seriously injured he was. He knew he had cut him. That's as close as he gets to it, and that's arguably both deadly force or non-deadly force in terms of its argument.
Do you agree with counsel that the arming with a knife takes this out of excusable homicide?
Well, you know, the interesting thing about the excusable homicide instruction is it actually kind of has three parts. The first one is when a killing is committed by accident and misfortune and doing any lawful act by lawful means with usual ordinary caution and without any unlawful intent, or when the killing occurs by accident and misfortune in the heat of passion upon any sudden and sufficient provocation, or when the killing is committed by accident or misfortune resulting from sudden combat if a dangerous weapon is not used and the killing is not done in a cruel or unusual manner. So there's actually three ways to accomplish excusable homicide. So that's exactly what I mean.
If I heard you correctly, the first one would cover this situation, because certainly arming yourself with a knife and holding someone at bay is a legal act. And if, in fact, the victim fell into it at that point, then it would be excusable homicide, would it not?
I think either one or two, if you want to argue, Spite started running at him, which is what I think the testimony was. I think either one or two supports it. With respect to his putting the knife out, he never saw the defendant. He said he heard footsteps, and that's when he spun around with the knife and his arm outreached. And I also want to point out both of these men were heavily intoxicated, which is another reason why the jury was less likely to look at a second-degree murder conviction and more likely to look at a lesser included. And with respect to the lesser included, the battery instruction was given over objection of both defense counsel and the state.
One last question, I think maybe unrelated to this particular thing, but the defendant's theory of how this happened was completely inconsistent with the eyewitnesses, was it not?
Correct. And that kind of goes to your prejudice analysis and why, just because the instruction wasn't given here, that there's actually much more analysis that needs to be undertaken. I think I've done that in my initial and reply briefs and laid it out what the state's position is on that. And that's why you also have kind of this problem with choosing deadly versus non-deadly force. Walter Smith testified he's had the non-deadly force instruction be given, and he lost the same year as this evidentiary hearing. And that's part of the, calculus he explained in making his decisions. And I also just wanted to point out along the lines of the question that was came from the bench, Nixon, United States versus Nixon, permits trial counsel to confess to the crime on behalf of the defendant and then go through the rest of the trial and death penalty proceeding. So trial counsel here can clearly make a tactical decision on what instructions he believes will be more believable versus less believable. And with that, the state asks that you reverse the order of the trial court in this case, granting a new trial on post-conviction relief. Thank you.